Mary redeemed a $50,000 cash prize playing Chumba Casino this year.
I was only playing for fun, so winning this was a dream come true.
Chumba Casino is America's #1 social casino experience. It's serious fun. With over 80 casino-style games to choose from, you too could win life-changing amounts of cash. Be like Mary. Log on to ChumbaCasino.com and give them a whirl. That's ChumbaCasino.com. No purchase necessary. Void where prohibited by law. 18 plus. Terms and conditions apply. See website for details. The voice in the preceding commercial was not the actual voice of a winner.
Hello, and welcome to the Proactive Caregiving Podcast. As a CPA with over 20 years as an industry accountant, Jessica stepped away from the corporate world to become a full-time caregiver for her mother. Having learned invaluable lessons along the way, she is now here to share those with you and to invite you to join her on this caregiver's journey. Here is your host, Jessica Cannon.
All right. Hello, everybody. We are back today. I had to bring Virginia Sampson back on because even though last time we talked about compassion, this leads into this part of compassion. I guess you can look at it as a legal way of having compassion, but not entirely. So we know caregivers come from all walks of life, but not all caregivers have legal rights to care or do some of the things that are necessary to protect their loved one's best interests. So today I wanted to have Virginia back on because as an attorney and from her own life experience as a caregiver and from her practice, she knows more than anybody else at this point the importance and the absolute need for caregiver compliance. And so in that vein, welcome back on, Virginia.
Thank you, Jessica. I'm happy to be here.
I'm so glad you are able to do this because it's not something that is out there for caregivers to know right off the bat. And I personally did not understand or need this until I kind of stumbled into this within a support group. And the caregiver compliance, it sounded odd to me because this is for me in my situation, it was my mother. Why do I have to have the right to care for my mother? But now, after living several different scenarios, I now understand yes, anyone can care for their loved ones, but even with spouses to an extent, there is a legal right that caregivers either have or don't have. So what would you say is the best way to kind of explain this risk management form through the legal documents?
Well, you're so right. We tend to think that because it's our husband or our wife or, our parent and we're taking care of them and we know everything about them, that somehow everybody's going to listen to us automatically, right? But it's not true. There are state laws, and each state is a little different. There are state laws about who can make decisions for other people. And so if you want someone to recognize it, whether it's a bank for a financial or the hospital for healthcare, most of the time you have to have the designated form that's sanctioned by the legislature here in the state of Texas to be able to make decisions for your loved one in whatever arena it may be. So I typically recommend, there's like 5 basic documents I think caregivers should have. And so one of them is, do you want me to just continue?
Yes, please.
Okay. So if you want to handle financial matters, right, if you're married, if you have joint accounts or joint assets, it's probably not too much of an issue unless it's real estate or cars, things that require titles. Because believe it or not, you as a spouse cannot sign the deed on behalf of your spouse, even if they're incapacitated, without having proper legal authority. And so for financial matters, that proper legal authority is called a statutory durable power of attorney. And what that does is appoint an agent. So the person executing the document, so say, for example, my mom took care of my mom, and she needed me to make financial decisions for her. So she signed a durable power of attorney that appointed me her agent to make financial decisions for her. And can be rather complicated or very simple. The state has really expanded the powers. You can give somebody absolute power, you can limit it. But the idea is that someone is going to be able to make financial decisions for the person who signs the document. And that can come into play, like if you want to put your loved one needs to go into a community, lots of times they don't want to admit them unless you have this document.
Right.
Because they need to know who's going to make financial decisions for the person, the resident.
Definitely, that resident, and that's definitely one of the things I experienced myself is who's financially responsible for it, because you're dealing with someone who may be mentally incapacitated, and how do you press responsibility on that individual? You can't.
Yes, and
right.
So if you do one of these, I recommend that you take it. So if you do it, and it's executed, it has to be notarized, then you provide a copy to all of the banks or any financial institution where the person who signed the document has accounts. Because they have a certain number of days in which to object to it, and if they don't, then they've accepted it. And even if you don't need to make decisions for the person right now, the bank has that form, and so you don't have to jump through a lot of hoops if something happens and you have to make some decisions for the person.
Right.
So that's very important. And again, if your loved one becomes incapacitated mentally, you've already got that document, and you can make that document effective the day you execute it, or wait until you're determined to be incapacitated. So with younger people, I say when they become incapacitated, if it's an older person with some health issues already, I usually recommend that become effective the day they sign it.
Definitely. And so that definitely becomes the best practice, I guess, as far as timing goes, because that is the question I've had too. When is a good time to do this?
So I went through this with my own parents, right? So my parents didn't move to live near me till my mom was already kind of ill. She already had some dementia and a variety of other health issues. So we didn't have these documents when she came, and the issue does become, if your loved one has some mental impairment, can they still execute these documents? And the timing is important, because I don't mean to scare people, but if you don't have these documents, oftentimes you can have to have a guardian appointed for your loved one, which is a court proceeding, can take months or longer, and can be expensive because you really primarily have to have an attorney do it, and it can create family conflict because the judge is going to decide who's going to appoint this person, who the guardian is going to be, and that may not be necessarily the person that your loved one wanted, and everybody has different. Maybe 2 or 3 people want to be guardian, and it can create some conflict and stress not only for those people but also for your loved one. So I think sooner is definitely better. And I think before a person becomes sick is probably the best time. I just tell everybody over the age of 18. And when I'm talking to older clients, if they're already sick, they're feeling vulnerable, right? They're feeling already like they're losing control of their life.
True.
And they're feeling very threatened. So it's harder when they're farther along in the disease process, even if they're mentally still competent to do it,
right,
to get them to cooperate. So typically what I tell people is that this is for you to have so that you can have more control as you age, because we're all going to age. And the truth is most of us are going to reach a point where we're not going to be able to manage our own affairs. And who do you want to do that for you? And so when you sign these documents, you are able to select the person or persons you want to make the decisions for you that you feel will make them in accordance with your wishes.
Right.
So those are a couple of pointers. Do it early. Present it as you are going to maintain control. And then if it doesn't work with you talking to them, sometimes you can get someone that they trust, a minister, a financial advisor, an attorney. Sometimes coming from somebody other than a family member, people are more receptive to getting the documents done.
Definitely. It doesn't feel as invasive, I guess, when someone else is coming forward, because it's someone else is speaking to their best interest and whatever issues might be there with the family, because, family drama can take precedence sometimes. It's not so much of a threat at that point.
Right. And don't forget, people won't say to me, oh, my parents are healthy. We know that can change in an hour.
Right.
And, we all get along, and we know that can change too, because family members just respond differently to stress.
Yeah.
Right? You're all getting along now, but your parent gets sick, or somebody gets sick, and all of a sudden some people just come unhinged.
Absolutely.
And they're not very rational.
Right.
So, I would say just get it done sooner rather than later. And if you kind of present it to people like that, people usually know a last will and testament, right? And these are just kind of documents they should have, just like they should have a will, right? It's like you plan for your retirement, you plan for all kinds of things. This is just planning for the aging process.
That's true.
Because we are all going to age. So I try to present it like that to people, and then they usually feel much less threatened. I also get a question, can people with dementia or Alzheimer's execute the documents? It really depends where they are in the disease process. The standard is that they have to be able to understand the nature of the document they are signing.
Okay.
So people with dementia can do that. I mean, my mom had dementia, but it had not progressed to the point where she couldn't execute some documents.
Right.
So that's another reason sooner rather than later, because especially if they even have the beginnings of dementia or Alzheimer's, we know that can accelerate quickly. And you want them to be able to do it, because again, without the documents, then if it becomes necessary, then they have to go to court and have a guardian appointed, and then they lose total control.
Right.
So.
Right. And I'm glad you mentioned that, because it's especially for people who are in dementia, even depending on what form of dementia they have, there are the 7 stages. And when Mom signed her documentation and we went through this process, Mom was probably in her stage 3. So she definitely, there was some issues, but she still was able to sign the documents and understand what she was signing.
Right. They don't necessarily have to understand every nuance, but they have to know that if they're signing this document, that they are giving authority to another person to make financial decisions for them.
Right. Right.
So the basics, and it's up to the attorney whether they think the person is capable of signing the document or not. Like, for example, I'll just start a conversation and see if the person's oriented to what day it is, the date, the day of the week, what time it is, where they are, perhaps who brought them with them to meet with me, those kinds of things to see where they are in the disease process.
Right.
And I make a determination from there. And every attorney is a little bit different, but ethically, we should not be having people sign documents who cannot understand the nature of it and not understand the nature of the document.
Definitely. And so as the family comes forward to have the durable power of attorney created, I know in my experience, it was better to have a single power of attorney, which is myself, versus having multiple power of attorneys. Is that something that many family members would actually seek to have, or is that something that's just like preference?
It's a preference. You can have a single agent or you can have co-agents, and that's up to the person who's going to be signing the document. I always recommend single agents to my clients because I think that co-agents just raises the possibility of conflict. What if co-agents don't agree?
Right.
Where does that leave the person? And again, it's just right for family conflict, I think. Like, for example, my brother and I did it. He was my mom's power of attorney for financial, which was fine. And we would talk about things, but fortunately, we didn't disagree. But if we had disagreed, then he could just make the decision he thought was best.
Right.
And I think I just think that's a better way. That's my personal opinion. I know some lawyers will do co-agents. I just typically don't do that because, like we just said earlier, people may get along now, but the minute somebody gets sick, that can all change.
Exactly. And it does happen. So the durable power of attorney is coming from the financial and dealing for the business related side of things. What is the difference between the POA and a medical power of attorney?
So the medical power of attorney authorizes someone to make healthcare decisions for the person signing the document when they cannot make the healthcare decisions for themselves. So the agent on the medical power of attorney does not have authority unless someone has determined that that person cannot make healthcare decisions for themselves. Now, there is a statute on that. that sets out who makes decisions. And, typically one spouse can make healthier decisions for another spouse, even in the absence of this document.
Mm-hmm.
But again, what if something happens to both spouses, and then once the spouses are not available to make decisions for each other, it becomes a bit more complicated.
True.
So it's good, again, to have this document. And again, like I've had clients that have, several children, but they'll designate one on the medical power of attorney because that's the person they feel will make the healthcare decisions in line with what they want, maybe more than the others. So that's a consideration. Some people just do firstborn, right? Whoever the firstborn child is, people seem to understand that. So you can have co-agents again on this, but I'm not a fan of that.
Right. So then we have power of attorney, the medical power of attorney, and then what would be the next documentation?
So you should have a HIPAA release. So we know that there's privacy as far as all of your medical information, and that includes your spouse. Your spouse cannot have access to your medical information without written authorization from you. And I lived this with my dad. I mean, they sent my mom home from the hospital with pneumonia, and they wouldn't even talk to him about what medication she was going to take or what her next step was, because we didn't have this document at the time. They had just moved here. Mm. So it's very frustrating when that happens. So this one, you don't have to, you can designate everybody in the family if you want. It's not an either or. Basically, you're designating anyone that you want to have access to your medical information. If you're in this, doctors typically will have you do one when you come in their office,
mm-hmm.
part of their intake.
Right.
But that's usually just for that doctor. This is a universal one. And like, for example, if your loved one goes into the hospital, you would take it to the hospital with you as well as your medical power of attorney, and they would put it in the chart so that they knew who has access. And you may say, oh, I've been in the hospital and they've talked to me. Well, if you're in the room when the doctor comes in or the nurse comes in, that's considered implied consent.
Mm-hmm.
But if you want to talk to somebody, call them up or something like that, typically they're not going to talk to you without this. Hospitals have gotten very strict on that. So I would recommend that you have this and take it everywhere with you when you go with a loved one. Then you don't have to fill them out every place either. So.
Absolutely. Yeah. And I've had those moments with my mom when she had to go in for an outpatient procedure, and when I had to establish that I did have HIPAA rights for her to get her information. And so when they had the follow-up calls to check in on her afterwards, they were able to talk to me. And because I learned I can talk to them and I can give them every bit of information they need to know about her health and changes in medications and just other information that would be helpful to them in treating her. But they weren't able to talk back to me as far as her results and needs or treatments unless I had this HIPAA established with them.
Right. I even had one that they wouldn't even tell me when my mom's next appointment was without this. And another reason you want a HIPAA release is you're not going to be able to talk to your loved one's health insurance provider without it. So if there's a question about payment of a claim, if you don't have this, you're not going to find out about it.
Right. Yes, I had to email this before they would, even while I was on the phone with someone, I would have to email it and put the call on hold basically until they received it and could confirm it. And then they would continue on with the call.
Yes. And you can see, especially if you're the caregiver, how not having this is going to increase your stress.
Absolutely.
Right? Because you're not only taking care of someone who you love and who's ill, but you're trying to figure out how you're going to talk to people, in their best interest.
Right.
But you can't talk to them because, they're constrained by legalities. And they'll get in trouble if they talk to you without these documents. So it becomes this vicious cycle of stress for everyone. So just doing a little bit of planning can avoid all that stress. And you just have them, they don't need to be re-executed when you do them. I mean, typically I recommend people review them in 5 years if the person's still competent, because things change in the legal field and your loved one's situation may change. But if they can't, if they're, for some reason, they're mentally incompetent to do a new set, you have a set and you don't have to deal with this later on.
True. It's so beneficial to have this done, period, well in advance, instead of being in that moment, in that crisis moment, and then trying to get things established, especially if you're in that emergency moment in the hospital and you don't have these documentation. It like you said, it adds to the stress exponentially. So
and I've run to the hospital a number of times for people. And, sometimes I get there and they're able to do them. And sometimes, they can even be on a medication. They can be totally mentally competent. But if they're in the hospital on some kind of medication that's affected their mental faculties, they can't sign the documents then.
Absolutely. They still need it. It's situational at that point. It doesn't always have to be. And that was one of the things that at first I kept thinking, oh, we don't need this at this time. She's still okay. She still has her faculties. But then as time started to pass, and then I realized, okay, let's just get this while she has as much of her abilities and her awareness now than to wait till later. And then as the time progressed and we got to those later moments, I was so relieved that I had these documents, because I could see how difficult it would have been so many years later when she really wasn't doing as well.
Well, and remember too, as our loved one, their health declines or they age, they're more subject to being influenced by bad factors, right? So if there's a family member or a caregiver, you don't have these, admittedly, they can make them do new documents, but if you've got these documents, that's some safeguard against someone coming in and influencing them when they're much more vulnerable and fragile, and appointing them when they don't have their best interests at heart.
Exactly.
So that's another reason I recommend it, is if they do it while they're, lucid, they're functioning, they're not feeling vulnerable, they're more likely to make a sound decision for themselves.
So true. And so one of the next documents, it always made me feel uncomfortable, but we have to have this conversation with our loved ones as we care for them. The advance directive. What is this type of document doing for our loved ones?
So the advance directive is a person's end of life wishes in non-emergency situations. So you have two situations. One, if the doctor comes to your loved one and says, you have 6 months to live, even if we give you all aggressive treatment, you're not going to live longer than 6 months. Then they decide, do they want the aggressive treatment, or do they just want to be kept comfortable and allowed to die peacefully? So that's one situation. The other situation is if they have some kind of like a stroke or something, and perhaps they're in a coma, they're hooked up to life support, some life-altering event like that. The same question. Do they want to be maintained with all aggressive treatment, or do they want to just be kept comfortable and allowed to die peacefully? So they have two situations in which they'll make an election. And I would say this is only if you can't make the election at the time it happens, right? So if you're, it's like the healthcare power of attorney. If you can make your own decision at the time, you're not bound by this. But if you can't, then they will follow your wishes, but also it takes some stress and pressure off your agent for medical issues, because they don't have to make this decision for you. They know what you want. And that's, kind of a gift to them not to have to make a decision like that.
This one was a difficult one for me, because even though Mom still had her faculties when you start talking about the end of life, it gets to be very emotional. Mom coming from that depression side quite often, more often than not, I always felt like that end of life choice was because she didn't like aging, and she certainly didn't like the way she was aging. And so she was just ready to give up. But then later on, with another conversation I had with my cousin even, who she's already gone through this process with her dad. And she reminded me to make sure I always had the advance directive on hand. She actually asked me, do you have one? And I said, yes. And she looked around. At this time, we were actually sitting in the kitchen having a conversation. And she looked around the room and she said, where is it? And I said, oh, I have it with me. I actually keep a copy in my car. And she looked around again and she goes, but I don't see it out here. And I said, well, why? And she said, if you have that emergency moment and you've got to call 911, you got to call that EMS, you need to pull that copy off the refrigerator or pull it out of your drawer, and you need to hand it to them, because when it comes to end of life situations and you have those emergency moments and you do have to call 911, their response is to fight for life. And if your loved one has already signed an advance directive that says do not resuscitate, you're going against their wishes. And if you are going against their wishes because emotionally, when I had this conversation with my sisters, they didn't like that idea of having to let go of mom. It's one thing when your loved one is sick and they're deteriorating by the day. There's an end in sight that's actually coming. But it's another thing when it's in that emergency moment and you don't have that moment to say, but I didn't get the chance to say goodbye. Or, if a heart attack or a stroke happens, it is still something that they chose in advance. And part of that process of the fight for life with an EMT, for example, if they have to administer CPR, for example, that may actually break someone's ribs. And the recovery process afterwards, someone who especially has dementia is going to recover slower than they would if they didn't. And so I realized at that point, okay, I need to respect mom's choices, regardless of if this is what she wanted. It's not just because she's coming from, I'm depressed and I'm ready to let go of life. It's a choice she made, period. And that was really hard for me to accept it, but I accept it. And I have my copies in the kitchen. I had my copies in the car. I had a copy in my purse. If that's what it is, that's what it is.
Right. And I think that's a conversation that's important to have with our loved ones. Again, it's not an easy conversation. They may want to avoid it, but I think sometimes if you do like you did, you put it in terms of, having more control over your life and getting what you want, people are a little bit more receptive. Also, if you do it again before they're vulnerable. Mm-hmm. And there's another complementary document to the advance directive, which is the do not resuscitate. I think people have heard a lot. I usually get questions when I speak about that. It's called a DNR. And it is a complementary document to the advance directive. And what it does is it tells the EMT, if you call 911, there's 5 situations listed there where they will not provide care. And one of them is, like you said, they won't do CPR, but there's some heart conditions. Anything, if you've kind of stopped breathing or functioning, they won't revive you. And the 5 are listed in this document. And you can find it. It has to be signed in conjunction with a physician. Mm-hmm. So if you're interested in that, I'd encourage you, I think it's available online somewhere, or you can get it from your physician, I think. But you fill it out, and then the physician has to attest that the person who's signing it is mentally competent. And then it's a valid document, and that, along with your advance directive, are things you should have available if you need to call the EMTs or even in the hospital at times. So you would want to take those documents in with you.
Absolutely. So then when you have these documents, and we've got the HIPAA and we've got the established POA and the medical POA, well, what is the other? I think there is a legal guardianship. Is that something that is done in congruence with this, or is it something that's only needed when there's not a designated POA?
No, you can do a declaration of guardian. I mean, if you don't have that and you have all the other 4 documents, I wouldn't worry about it. If I'm, helping someone, I would typically put that in the packet, but it's not super critical. Mm-hmm. Most people, especially if you have these documents, you're not going to need a guardian to be appointed because someone should be able to manage your affairs with the other 4 documents we've talked about. Mm-hmm. But basically what this is you are telling the court, you're still going to have to go to court, but if a guardianship proceeding is initiated, it's the person's wishes as to who they would want to be appointed a guardian. So there's a guardian over the person and there's a guardian over the estate. Mm-hmm. They don't have to be the same person. And typically the judge will honor the wishes for the person who signed this declaration of guardian, unless there's something in the background of one of the people that is a red flag, embezzlement or some kind of criminal activity or something unsavory. But typically your wishes will be followed. And again, with all of these documents, recommend an agent and at least one successor agent be appointed. In this case, a guardian and an alternate, because, someone may be out of the country, they may be unavailable, something may have happened to that person, and maybe the loved one isn't able to execute a new set of documents because of some impairment. And so if you have 1 or 2 successor agents, you don't run the risk of having the document invalidated because the agent is no longer available to make decisions. And so on this, again, you would want to make a choice. And on the declaration of guardian, you can also exclude people from being your guardian. Maybe you have a child or a family member that isn't good with money. You don't want them being appointed the guardian of your estate.
Right.
I had one client who had a son that was a doctor, but she didn't like what he suggested for her for health care, so she excluded him for the guardian of the person. And so it's probably a document you're not likely to use, but if you do need it, you've got your wishes expressed again.
Right. So then once we have this nice package of documentation, we have our caregiver compliance in place, because there are 4 different types of caregivers. Obviously the family caregiver, but there's the professional, the independent, the private, and that falls into informal or volunteer caregivers. But once you get this packet of documentations and we are compliant, what should we do with these documents?
So on the financial power of attorney, I would recommend that you take it to any bank or financial institution where the person who has signed it has accounts, right? Because that's going to empower you to talk to that bank representative or financial brokerage account, whatever they may have. And again, they've changed the law recently, so they have to object to this within 10 days. So if they accept it, it should be honored. And so you don't have to worry about, a year from now. What people do is they hang on to these, and then a year or two from now, they go, oh my gosh, now I need to make decisions. They take it to the bank, and the bank says, I'm sorry, we're not going to accept this. And then the person's incompetent to do another one, to execute another one. So right away, take it to every bank and financial institution, give it to life insurance companies, anybody that, has a pension funds or, 401ks, whatever it may be on that one. You do need to keep the original of the power of attorney if you are going to ever sign the deed to any real property on behalf of the person, because you have to record the original power of attorney along with any deed. So I would say be very careful about retaining the original durable power of attorney document. It's very important for that purpose. The others, you're pretty much okay with copies on anything. Of course, you can give copies to all of the banks and financial institutions, but just be sure you retain the original in a safe place. I also recommend that you give copies to all of the successor agents, right, who may be listed in the document. So, you have multiple copies out there. And sometimes people will lose them, and then they can go call one of the successor agents and get a copy from them.
Right.
On the medical power of attorney, the HIPAA release and the advance directive, that probably should be in a packet that you take to doctor's appointments. And certainly if your loved one goes into the hospital or into a community, you're going to want to provide all those documents to whoever's in charge. Like with my mom, I would just give them to the nurse, and they would put them in her chart at the hospital. And so that then you don't have to, as soon as you go, then you don't have to worry about if something happens with your parent or your loved one, you have to make a decision quickly. You've got to go find the document and hand it to the person. It's already in the chart, and you're good to go.
Right. That definitely made it easier for me, making multiple copies and handing them out to as from the time we got it, as you said, I went directly to her financial institutions, and any life insurance or a retirement, I sent them that information right away. And then they, in addition to having that, sometimes, not all of them, but some of them did have their own internal form that they wanted me to sign and get, copy of driver's license, all that kind of stuff to confirm who you are. And they would attach that with the legal form as well.
Yes, lots of times they have their own forms, and it's good to do those while your loved one is still competent. Yeah, definitely get that done, I would say. And that's what I'm saying. If you send this out right away, then you can get all that in place. And I would recommend you send these to the health insurance company too. If they're on Medicare, you can give it to the government. If they've got a private insurance company, send it to that insurance company so you can talk to them about claims, and get authorization for any treatments that may need to be done that need pre-authorization, because they'll already have that documentation.
Right.
Oh, and one thing people do ask me when they do these documents, a lot of my clients will say, well, I don't want to send, one of my children or my brother or something, because I'm not going to list them. You're not obligated to disclose who you've listed or not listed. So you can give it to the person that's the agent and any successor agents, and you could just ask that they not share that information. But it's not like you have to make an announcement to your whole family who you've selected as agents.
Yeah, because that might actually add to the family drama. Why did they choose
because
you
then you
instead
might
of
get
me?
some pressure.
Right.
Yes.
So
So maybe just don't tell that person.
Exactly. And that's something that, when, especially for the families that are well ahead of the game and they're taking the proactive approach to this, they can say, I want the child, either the firstborn, or maybe it's not the firstborn. I know that's what happened with when my dad passed. When it came time, since he didn't have a living will and he didn't have any of these documentations on hand, a lot of the decision making fell to firstborn. That was just their designation. And even still with that, we tried to come together to make decisions. And there are those moments, sometimes we agreed on everything and other times we disagreed. And it's a delicate situation at that point to get through things smoothly and not add more anxiety and stress to the whole situation.
Right. And let's face it, most families, we're going to talk to our siblings about it or, your other parent about it. But somebody has to make the decision if everybody can't agree.
Right.
And
someone has to
that's a tough spot to be in, but it's necessary sometimes.
So what happens when, say, for example, the children they know their parents, adult children know their parents, they need this, and they're trying to bring it forward, but in some cases, that person that's already ill or aging abnormally, they perceive this as that threat, as like we were talking about. What can be done, or what do you do when you have that care recipient that fights this process for the documentation?
Well, I think that's when you're going to try to get somebody else involved. And remember, one reason you want to do it early, like my mom had dementia, one of the symptoms of dementia is paranoia, right? So the farther they get in the disease process, they become paranoid and they're not going to cooperate on anything. But in my case, like with my mom, there was a medical professional that she trusted that we had talked to her about it. I've had some people have their minister talk to their parents or their loved one about it. Some people respond to lawyers. They set up an appointment to come in and see me, or they have a financial advisor they trust, or just a close friend. Someone that they have confidence in, whose advice they would be open to, maybe a good person to talk to them. And you might just want to bow out of the process, right? Set up the meeting and don't stay there, because then I think loved ones can feel pressured. You just let those people have their conversation without you being present. And I think the loved one feels a little bit more comfortable discussing things if they feel like they're not hurting someone's feelings or someone isn't listening in on what they're doing.
Right. Because that is definitely, and it adds to it. It's that paranoia, that perception of you're just doing this to take this away from me, or whatever it is in their mind.
Right, and that's the thing. That's why I think when people get sick and feel vulnerable, even if they don't have dementia, they're less likely to execute these documents because they already feel like they're losing control over their life. And their perception is that this is going to make them lose more control, which is the opposite. It's going to give them more control, but, they don't see it that way. It's fear-based.
Exactly. And there's a lot to be fearful about, because, when it comes down to the unknowns, and, you can be proactive and plan as much in advance, but there's always those unknown scenarios. The beauty of it is, by having these done sooner than later, those unknowns, there's less fear in that. There's every moment I had, every situation I had where I was taking mom to the hospital for outpatient procedures, those questions would come up, and it was a relief that I had an answer, or I had a document, or I had something that I could just, here you go. And it was nice that I could just step back and say, oh, I'm glad I did that, or I'm glad I had that, because the times before that, uncomfortable, very uncomfortable. And the stress of what if this, what if that, I should have this, I should have that. And all of that went away once these documents were in place, because now it felt like someone answered those questions for me in advance. And it was also something that it was including my mom in the process, so that it wasn't that fear of, you're taking this away from me. It's, when it was more so that, well, Mom, I want to do the best I can for you. I want to come from a place of your best interest, but I need you to be together with me and work with me on this. And so it kind of gave us a little bit of a moment to kind of come together on.
Well, yeah, and I think sometimes if you can present it, you know what resonates with your loved one, but if you present it oftentimes and say, look, will help us work as a team, and also it's going to reduce my stress. It's going to allow me to concentrate on caring for you because I don't have to worry about all these legal issues.
Right.
They're all resolved, and I can just focus on you and getting you the care that you need. That often resonates with loved ones when you're, asking them to execute these documents. And also I tell people, adult children that come to me, do you have these documents? If you do, then you tell your parents, look, I have these documents. People have these documents. It's like having a life insurance policy.
Mm-hmm.
And that resonates with a lot of them too. Then they feel like, oh, okay, so I'm not being picked on because I'm old and aging, but this is something everyone does. And they're much more open to it.
True. That feeling of this is normal. This is okay.
Yeah. This is just what responsible adults do. They have these documents.
So, and these documents, in a way, it almost became, it was that legal mediator for me where when the disagreements did come up with my siblings, sometimes we were able to talk through things and figure out what is the best approach or best interest. And other times we just locked horns and we could not decide one way or the other. And that documentation that was put in place just basically said, we're going to have to agree to disagree. This helps me to take precedence and I need to move forward because the longer we spend time arguing and disagreeing is the longer she goes out without what she needs.
Yes. And that's a good reason to just have a single agent rather than co-agents. Is the single agent, obviously, most of us are going to ask for the input of our siblings, our loved ones, but if we can't agree and it's hurting our loved one, then we're just going to make the decision.
Right. And so getting all of this documentation put together, this helps caregivers to be in compliance. They have the risk mitigation, having these forms. It's the peace of mind and all of that. But you can also take that extra step if you're going to be in the process of putting these documents together and having your loved ones sign in advance, then the next step would be looking in towards their estate planning. And that's creating trusts or irrevocable trusts. Is that something that, I guess for me, having the power of attorney helped me be able to move forward? And so it may not have all been at one time, but it just seemed like that was the natural next step to do.
Yeah, so if you don't, the basic document is a will, correct? And I can say if you don't have a will, you're going to have a much more expensive probate process. Now, some people don't need probate, but if you own anything like a house, any kind of real property, you're probably going to need probate because somebody's going to have to now own that property. Mm-hmm. And that just doesn't happen automatically. So you are increasing the stress for your loved ones and you're increasing the cost because the court first has to determine who the heirs are, right? And then they can probate the will. It also is critically important in second marriages where you each maybe have kids from a previous marriage. You can leave your spouse a huge mess. Mm-hmm. And I mean a huge mess. And talk about family conflict. Right. So I would suggest that at least do a will. If you want to do more estate planning, there are revocable trusts, there are irrevocable trusts. A lot of people don't need those. It just depends on the type of assets you have, how much you have in assets. Most of us, I think, especially as we get older, most of us, a will is okay, but certainly there's other things you should consider. There's also, we didn't touch on it, but there's government benefits available to pay for long-term care. I just want to touch on that. It's not necessarily estate planning, but irrevocable trust can come into play on qualifying for some government benefits. There's Medicaid, and there's actually veterans benefits that are available to help pay for long-term care, because we know that can be expensive. So sometimes consulting with an attorney to put a plan together is really beneficial. You can touch on all these things. and see whether, trust is appropriate for you. Are your loved one eligible for some government benefits? If not, how do they become eligible? And that's kind of what elder law attorneys do. We try to help prepare plans. Typically, we're called in a crisis, which, as we know, costs more and you have fewer options and you're not going to get as good a result. But, if you're proactive and plan, you can really be prepared and really reduce your stress and the stress of your loved one by having some type of a plan. I'm not saying you're not going to have to tweak it or, something may come up that's going to change it, but it's like anything in life. You have a plan, a roadmap that's going to reduce your stress and help you give better care to your loved one.
Absolutely. This is a stress reliever all the way around. I mean, and like I said before, this is another form of compassion by helping to relieve the stress of your loved one and for yourself. It is a game changer when it comes to caregiving.
Yes, and it's about control again, too. If you're doing a estate plan, you're going to determine your property will pass according to your wishes. If you don't have a will, it may not. Especially if it's a second marriage, you can just about guarantee it won't.
Right.
And so if you want to have more control over your life and what happens after you're gone, you would want to have some kind of a basic estate plan at least. And of course, you want to tap into any government benefits because that's going to help your loved ones pay for long-term care.
And that's very expensive. That's something that should not be dismissed or denied because long-term care is, I think that's kind of what bit us in the butt, so to speak. There are those moments where we say, we've got time. We don't need this right now. Later, I'll get to this later. And that is definitely something you don't want to postpone.
Yes, and even like Medicaid, which is the state program that pays most of the cost of skilled nursing, if your loved one is incompetent, somebody has to have the power of attorney to be able to go forward with the application process.
Right.
If you don't have an agent, you may be barred from going forward with the application process for Medicaid. So it's critical on so many levels.
Yeah, this is not exactly something that a very compassionate neighbor can step in and say, I can help you with this. They may be able to make some phone calls, but when it comes down to it, you really need a designation, someone that because, we live in this litigious society. So, everyone's coming from one perspective or the other, and they're going to protect themselves from any legality. And you've got to protect yourself to be able to step forward and deal with the legal issues. So.
Right. And, if you just start doing it without legal documents, you can run into some problems with your siblings. First of all, people may not respond to your request, but also you could get in some hot water with your siblings.
Right.
So it is partly a protection for you too, that you are the authorized agent to make these decisions.
Exactly. Well, Virginia, thank you so much for coming back to speak with us again and explain the difference of this caregiver compliance and all the documentations and what they're for and how we can navigate our caregiving journey with this compliant package. I really appreciate you taking the time to share this with us.
Oh, thank you, Jessica, for having me on. I appreciate your input into this as well, because I know you have a lot of personal experience with this, and I know that's invaluable to people. So
Definitely.
Thank you for having me on and for wanting to, help people with this issue, because it is a very critical issue.
It is. We learn as we go, and I know that by sharing this and helping others, maybe it'll make a difference in their lives. Maybe they'll be able to address it sooner than later and avoid some of the difficulties that I went through. I don't know. But if that's how it works out, then all the better. So I hope this gave you more food for thought. And until next time, be proactive. Take care, everybody.
Thank you for joining us today. We really hope you've enjoyed this episode. To learn more about proactive caregiving and to hear other episodes of this podcast, please visit www.jessicalazelcanon.com. This podcast is produced by Canon Light Media, LLC, www.canonlightmedia.com. Music provided by Chris Paradise.
Mary redeemed a $50,000 cash prize playing Chumba Casino this year.
I was only playing for fun, so winning this was a dream come true.
Chumba Casino is America's #1 social casino experience. It's serious fun. With over 80 casino-style games to choose from, you too could win life-changing amounts of cash. Be like Mary. Log on to ChumbaCasino.com and give them a whirl. That's ChumbaCasino.com. No purchase necessary. Void or prohibited by law. 18+. Terms and conditions apply. See website for details.
The voice in the preceding commercial was not the actual voice of a winner.